persons have been given the medical record, the others have not been given. This is the situation which we are facing. This is precisely the injustice which is being done to whether UCC is responsible. UCC naturally is responsible initially because the gas leaked, but then subsequently the Union of India should have probably done this thing which it has not done. I cannot shy away from that fact. I have to mention that. Now, kindly look at page 29 onwards, para 29 onwards. Page 50. Page? Okay. The Lordships have that judgment in 1991 for SCC, page 88, yes. Para 29 of the compilation.
Which page is it of the compilation?
Volume 1 of the respondent's compilation, page 88.
Volume 1.
From which,
what is the paragraph number?
Paragraph 29.
The toll of life.
6.2 it will be.
If we have the curative petition, sir, उसमें page 21 पे.
No, we saw
If we have the curative petition, आपके पास है ना? उसी में page 21 पे review order. Yeah.
The toll of life has since gone up to around 4,000. Now 3,000 was the figure in 89, it became 4,000. And the health of tens of thousands of citizens of Bhopal city has come to be affected and impaired in various degrees of seriousness. The effect of exposure of victims of methyl isocyanate, which are stored in considerably large quantities in tanks in the chemical plants of UCIL, which escaped on the night of 2nd December, both in terms of acute and chronic episodes, has been much discussed. There has been growing body of medical literature evaluating magnitude and intensity of health hazards, which the exposed population of Bhopal suffered as immediate effects and to which it was potentially put at risk. It is stated MIC's most toxic chemicals in industrial use. Petitions rely upon several studies carried out in toxicological laboratory, etc. So it was initially assumed the MIC caused merely simple and short-term injuries by scarring the surface tissues owing to its high exothermic reaction in the water. It has now been found by medical research that injury caused by MIC is not mere surface tissue of the eyes and lungs, but is of entire system, including nephrological, lymph, immune, circulatory system. It is even urged that exposure to MIC has mutagenic effect and the injury caused exposure to MIC is progressive. The hazards of exposure to this lethal poison are yet an unknown quanta. 32. The estimates of concentration of MIC at Bhopal, fateful night by the board, indicate concentration of 26.70% parts per million. The work environment. This has led to what can only be described as grim and grisly tragedy. Indeed, the effects of exposure of human system to this toxic chemical have not been fully grasped. Research studies seem to suggest exposure to these chemical fumes renders the human physiology susceptible to long-term pathology, and toxin is suspected to lodge itself in the tissues and cause long-term damage to the vital system, apart from damaging the exposed parts such as eyes, lung, membranes, etc. So also alleged that the latency period for the symptomatic manifestation of the effects of exposure is such that a vast section of the exposed population is put at risk, and terms of effect is presently unpredictable. It is said that even in the cases of victims presently manifesting symptoms, the prospects of aggravation of the condition and manifestation of other effects of exposure are stateable possible. Immediately symptomatic cases showed.
These are all arguments.
These are Milord, submissions which are made. On the basis of this submission, Milord, these are what has been said. Just look at 33, last one.
Yeah.
One of the points urged is that likely long-term effects of the exposure have not been taken into account in approving the settlement, and the only way the victim's interest could have been protected against future aggravation of their gas-related health hazards was by incorporation of an appropriate reopener clause. Now, this argument continuing, and 135, which your Lordship pointed out, ultimately in para 205, etc. Well, kindly look at 135. In between the contention of Lord, Mr. Nariman will come, but then kindly look at 135. Page 1. Yeah. No, 134 also, if your Lordship look at, and then 135 bottom I will point out. But the petitioners say that in process of evolving what is fair, reasonable, and adequate settlement, some of the elements essential and element of fairness and adequacy, such as provisions for future medical surveillance and the likely future, but yet unforeseen manifestation of toxic injury, having regard to the nature of hazard, have not been kept in mind, and therefore the approval according to the settlement is on a incomplete criteria. But UCC would say that Union of India was aware of the possibility of such future manifestations, of the effects of the exposure, and must be deemed to have kept all those in mind at the time of settlement. Now, the last sentence will come because kindly read this and then I'll read. The principle, that is fourth line, is rightly pointed out by Nariman, take care of the victims who manifest symptoms. But what about those who are presently wholly asymptomatic and have no material to support a present claim? Who will provide them medical surveillance costs? And if at one day future they develop any of the alleged symptoms, who will provide them with the compensation? Even if the award is once and for all determination, these aspects must be taken into account. And then it goes in, Lord, what my Lord had pointed out at page 205, I suppose.
Para 205.
Para 205, sorry. Para 205,
So,
which my Lord had.
are there any cases which are asymptomatic at that time?
Yes.
Later on, somebody.
Yes, yes, I'm going to show to Milord from their company.
So those cases could have been covered by insurance.
They should have been covered by insurance, but then, Milord, what is happening like in renal failure? That is again, Milord, what has been said by Lordships is where, Milord, a claim has not been filed. That's not
Claim not filed at that time.
at that time.
So this contemplates somebody filing claim subsequently
It
who
has
develops
to-
something.
It has to be made clear, Milord, because not.
That is what is very clear.
If you file a claim now, Milord, because the medical
It's not a claim.
insurance policy have not been taken, then will not be.
Then the government should have done it. Secondly, please always keep in mind that both cancer and renal failure incidents today, forget Bhopal. Otherwise, around also there are a number of examples which occur. Therefore, which case is linked to this problem? In which case is
Causation
scenario?
is a big issue.
Causation is a big issue, as my mother.
Milord, this is
Mainly
actually,
because in Bhopal somebody has cancer or has a renal failure, can we say that that must be attributed or causation must be attributed to?
it's not, I'm not going to show anything from I am going to show from the records which have been filed by Union of India. And let me finish three more, and then I'll just show that I think that will be end of my arguments.
You have 6 minutes. Yes, adding 1 minute of.
Categorization of victims was done in absence of medical records. I'll borrow actually 5 minutes from Mr. Sarve, if you will. More. 4 minutes.
Money will pay.
Categorization of victims that was done in absence of medical records, because of which.
Mr. Parikh, except additional amount is willing to give you everything. Mr. Sarve.
Time is not a problem. In yesterday, when 10 minutes were indicated, he said, no, let them take their own time. No difficulty. So, categorization victims was done in absence of medical records, because of which the victims and dependents being deprived of fair assessment of their injuries, even death cases, an award of compensation based thereon, and enhancement of compensation if with passage of time the injury is aggravated. I must point out to your lordships that this issue arose, and this aggravation of injury part is in pending in SLP, which your lordship said that we'll take it up after the decision in this matter by the curative. The process of finalizing medical records is still not complete. See the last order, 3/1/2023, passed by the High Court of Madhya Pradesh. Can you just have a look at that order? And yeah, after the note at the end, we'll not just look at the order. No, there was an order in 2012, lordships may recall. Sorry.
Just repeat. Just repeat.
Sorry, no, what I was saying is about the medical record, that the position of medical record is indicated in the High Court order of 3rd of January 2023, which is at the end of note. Just kindly have a look at it. I must point out, Milord, there was an order of 2012 passed by Justice Swatantra Kumar, by which the matters were sent to NGT, etc. It was in the same matter. They said you go to the High Court. So then we went to the High Court, filed a contempt. Just look at, Milord, the position in the para 2. It is pertinent to mention that the last report of monitoring committee in return of respondents disclosed number of deficiencies in compliance made as regards directions contained 59(9) of the aforesaid order of tax code, including that nearly about 76,000 health books medical records have been digitalized, as against more than 4 lakhs gas victims to whom smart cards have been prepared issued. made clear if satisfactory reply is not filed, then court may proceed call upon. So this is the situation in 2023. Then even now the people are searching for medical records. Now, yeah.
Harish, what I just wanted to know, as a matter of fact, what happened to where the factory was located, the land, and what is
Yes,
happening?
Milord, I must come there. Milord, in one of the cases, Milord, which is concerning dumping of hazardous waste in the country, this was also looked into by the committee which was appointed by the Honorable Court. They went there and saw the situation. The water was also, drinking water was contaminated. They suggested drinking water should be supplied. And that question, Milord, drinking water is pending. But besides that, Milord, ultimately, the toxic waste which is lying there, that has to be, Milord, disposed of. So there was again, Milord, it was looked into by the Honorable Court, and a sample of waste was sent to, I think, Taloja, Pithampur in Madhya Pradesh, and then the costs were incurred by the Union of India and Madhya Pradesh. I think they shared the cost. And beyond that, Milord, that what kind of emissions will be there, because they should not be too toxic, which will be health hazard. It is, Milord, there, and I'm told that the waste has been put in some kind of a, how much? 1.1 million contaminated soil is there, which has to be ultimately incinerated, because we can't put it in landfill. Landfill will not be
But
water.
in 40 years, what did the government do?
Site possession was taken in 84 by the CD Act.
So something, I mean,
It's not very.
for everything, they need a court's order to do it.
That's not very.
And then they say the court passes orders.
The court passed some order, it was not done, then court again passed the order, then it was transferred to High Court. High Court will look into it. We do not know what is happening in the High Court. It's now in the High Court. Pending in the High Court. Like this matter is pending in the High Court, medical records. Lordships directed you must do it within a given time. Medical records not prepared. That is also. And what will happen, because you will inhale this kind of a dust, which is toxic in nature, and the water is
It must be
contaminated.
stored in some manner, right?
Multiplying problems.
Some storage manner must have been done, or
No. Subject to Milord correction, I should not immediately say. But as much as I know, because I appeared in some of those matters, nothing has been done. Some waste must have been put, Milord, in the bags, etc. But then nothing. The entire, and that is there. So therefore, from there, by leachate, Milord, it is going into the underground water, contaminating, and then
I don't know.
this is.
But
We'll put it on record.
very basic common sense would require that the issue of how the area has to be tackled with should have met with priority from the government authorities.
That's correct. No? They can't depend on, because they can recover from UCC. That's a different thing. That's what we said, that you must do it, Milord, in those proceedings in hazardous waste. You must do it and recover it from UCC, whatever you want to do.
That's the second stage.
Yeah.
First thing is, what have they done? You're talking about 40 years or
Nothing.
decades.
They have not done.
Okay.
Now, Milord, para 12. The Office of Welfare Commissioner has been submitting fortnightly reports on number of victims whose claims have been processed and sanctioned. Last of such report is 15/12/2022, shows the increased number of sanctioned cases of deaths, permanent disability, temporary partial disability, as well as number of cancer and renal failure which have been sanctioned. Just look at, Milord, the last page 1633 only. It's a compilation to volume 4 of Union of India.
What does it contain?
It contains, Milord, the fortnightly reports on number of victims by the Welfare Commissioner. So I want to show to the Lordships, Milord, these are identified cases, because Lordship said that it depends on renal failure cases are taking place and cancer is taking place, but these are all identified that because of inhalation and the money has been, and that's government document, not they have put it. Yeah, you have opened it. Just pass it on. This is a compilation to volume 4 of Union of India, page 1633. Only one page, I'm sure.
Status.
We updated the status. I have to show to Lordship. You can't object to the work being done by Union of India. They are providing ex gratia compensation to people. I must show that the number is increasing. That's all. You can't object.
We take it that there is an increase in number.
No, my lord, this is, can you look at this? Is a tremendous, not simple one. The number is increased. I show to your lordship. This is in case of how much is renal cancer cases are how many? Cancer cases are 10,547. No, here this side. I got it. It's at 10,000. And the renal failure are 1,726. The number of death cases have increased from 5 to something to 5479, and also the cases of increase of permanent partial disablement. All that figure will be clear. Lordship, got it?
Not yet.
I can pass on my. I don't want. Got it. The number is
It's last page of the book.
163, the last page. Now, the previous thing, these reports have been given from 2011 onwards. Because Lordship may recall, 2010, they came out with the ex gratia payment scheme of 10,000. So then they are monitoring it and putting the report. I'm so sorry, I got that.
Sure. Brother, see that the increase is from 5,200 odd to 5,479.
Correct, whatever it is. Whatever it is, and similarly there is
No,
a
but
increase,
this-
I think.
Tell us one thing.
Yeah, my lord,
One
Lordship,
minute,
look at the last one.
Just 1 minute.
Yes, sorry.
This is the people who may have passed away. What were their ages is not indicated.
I have no idea, my lord.
You are not
What is the causation? Causation is
Position, my lord, because this has been submitted ultimately by the welfare commissioner, and the causation, these are cases which are sanctioned. Kindly look at the last column here.
government may be helping, putting a helping hand to it. One thing.
My lord, they can't give helping hand, my lord. This is all cases of Bhopal case tragedy. Who have
I'm saying suppose somebody who
and they can
has
verify probably.
some effect of Bhopal tragedy.
I have no idea, not some or more. In fact, I am just putting.
No, I'm just saying the problem is at this stage to find a cause and effect, saying that this particular person, this disease is attributable to that. That's what we are trying.
I'll 10,000, 5,000 which they mention is the amount which has to be given in case of death and permanent disablement for Bhopal victims. It is not the continuation of that only. They then from 2011, I have shown the last page to Lordship. It starts from 2011, the monitoring reports are from 2011, how much money has been given. This is the approved cases, progressive ex gratia cases. There are approved cases, I am reading only that. The approved cases of cancer are 10,547.
Correct, but whether amount compensation is paid to them or
2 lakhs, Lord, they have determined in case of renal failure and cancer.
2 lakhs.
Yeah, 2 lakhs. Ex gratia they have paid. Now, that question, Lordship may decide that who should pay,
No,
because
I thought
the judge.
It's for just one correction. I think as per the rate fixed by the government for renal failure, it's partial renal failure, disability is 5 lakhs, not 2 lakhs. Subject to correction.
2 lakhs, Lord.
So if you look at the figure given at page 1633,
Yes. Which column, you know?
the rate by GOM is 5 lakhs.
Yeah, 5 lakh is not permanent partial disability.
Yes.
That's all. That
In
that-
case
that's
of
what I
renal
said.
failure, it's not treated as permanent.
No, it's not treated. They give 2 lakhs, not as lump sum.
Okay.
Both cases in cancer and renal failure, 2 lakhs are given.
Okay.
And they are paid. I'm not saying that this payment is being done.
They don't
It is done
treat these cases as falling in utmost severity.
at most severity.
They don't treat those cases as falling in
No,
this category.
no. Separately monitored. No? These are, yeah. Cancer and renal failure cases are separately monitored. But then why I was reading, where at 29 onwards is linked with this. These cases will keep on increasing. Therefore, at that juncture when you said this is the amount and this is the number, may not be. So at some juncture will not, even after 1 year, suppose the situation becomes drastic,
That is
somebody
why,
may come
that
to you
is
and
why,
say whether Union pays or they pay is a different.
that is why the review judgment said that there may be possibility of other cases arising.
Correct.
Therefore, take out the insurance policy to cover that scenario.
But that's again the question is like renal and cancer. Then nobody knew that these things will happen because that's why I read out 29 onward.
Correct.
Only for that purpose.
You are saying that these cases should have been treated as falling in second category.
Yeah.
Has anybody gone to the government with that case that you pay more?
No, you gone? No, have you gone making this claim of that should be treated as a purpose? They have gone this way. There is an application.
This is for the government. Therefore, I am saying
Since his time is over, I will point out, there is a parallel proceeding pending in this court by these people claiming more, where the government, and I'm going to read those affidavits, has filed an affidavit saying everybody who's genuine has been paid, all these claims are wrong.
No,
I'll show that.
my friend is talking about the SLP. That SLP has to be taken. I have not argued the SLP because there is an order. It will be taken up
After this.
So if there is any argument, I don't think, because that is aggravation. What has been said, Milord, I must point out, the SLP is this. This simple has become, Milord, with passage of time, grievous. Grievous has resulted into death. Now the question is, when you go before claim, they say, no, we have given you claim for simple injury. Now we can't give you for aggravated. So therefore, now the situation.
So that claim is subject matter of that SLP.
SLP.
This claim, is that correct?
Correct. This government is opposing this, correct? They are opposing. I can't deny they are opposing. But the question is, High Court said, no, we can't do anything because that's the scheme. And now we are in difficulty because naturally, if somebody has died, then he has to be paid according to the death criteria. Only one prayer. That prayer is, Lord, kindly ensure the medical records to all these people. They are made available as direct.
you see, you have flagged two issues. In fact, one is just seeing para 13, correct?
Yes.
Medical servants are utmost
Correct.
important and medical home systems spanning, but that data has not been digitized. Number two is
13. That I have said 20,000 people are in. Now you can't say that there are minor injuries, that they are visiting hospitals for such a long time. But whatever it is, not in adjudication is something minor, I can't say anything. In appeal, you can challenge it. But truth is that they are suffering and it is categorized as minor. I am not making out any point that you lordship adjudicate, but this is a human problem. And it's a truth that people are suffering.
okay. Thank you.
I am very grateful to you.
Thank you.
But my time is over. I am very grateful to lordship.
Wait, please. Two or three things I want to assist you with. First is a commitment I made to someone. That commitment is to defend allegations of midnight setting. These allegations are haunted. The court has haunted certain very eminent people who were involved in the process of negotiating the settlement. It is very easy to allege this kind of nonsense. Very difficult for those who are called upon to make difficult decisions, to take responsibility. The Attorney General of the day said, my shoulders are broad enough, I take responsibility. I think this is the best for the people concerned. The 5 judges who sat there said, our shoulders are broad enough, we take responsibility. There is a whole industry of claim and claimants which has grown around this misery and this tragedy in India. 3 or 4 rounds of litigation have taken place in the United States after Judge Keenan transferred the union suit to India. In different formations, Sahu 2, Banu have brought class action suits in the US, where US people have given evidence. And that evidence is now sought to be introduced before this court, including in some of the papers filed by the government. Extraordinary claims made that the death rates in Bhopal are higher, and therefore 25,000 people have died, 30,000 people have died, etc. And all condemning this as a midnight settlement. But I want to start by telling your lordships that this settlement did not take place in 1989. This settlement started in 1987. The district judge took the responsibility of saying party should explore a settlement. We put all that on activity. Yeah. He passed a judicial order saying, please try and arrive at a settlement. The government of India rightly complained, saying Union Carbide is relying upon every possible legal defense, which they would, saying give better particulars, give this, give that, matter is not progressing. The district judge said, please try and explore a settlement. The Attorney General, who was appearing for the plaintiff in the Bhopal district, and Mr. Nariman appearing for the Union Carbide, two of the stalwarts who have assisted this court over the decades, started discussing settlement on behalf of their respective clients. The figures started with 350 and 500. The courts always felt that the gap was not that large. A little squeezing from both sides, things could move ahead. By the time it reached this court, it got narrowed further. Mr. Nariman's statement is recorded saying 420 and no more, or 430 and no more. The Attorney General said no less than 500. This court said if you give 470 plus interest, it will be 500. You are happy? You budge from 430 to 470? Surely your client can consider that one. They said fine. So the settlement was signed. This was challenged in 1991, and the prayer in the review was set aside this settlement, put the case back for trial. 1991 was 7 years away, but still, as compared to today, proximate to 1984 or 87, 88, 89 by the time it's a legal proceedings. Your lordship said the 5 judges who passed the order on settlement, and we all remember, you were much younger, but we all remember the huge rumpus over the settlement, including one conspiracy theory saying Mr. Rajiv Gandhi met Mr. Warren Anderson in some hotel in Paris where it was done. All these kind of nonsensical allegations. At a time when Mr. Warren Anderson had long retired from UCC. Your lordships felt the first bench which sort of accepted it, felt they must take their reasons. It's the strength of this court that your lordships are never embarrassed to say, in a case like this, we must tell you why we accepted the settlement. While doing so, your lordship said, if it is found, we went on the footing that Carbide has said 350, 370, 400, and no more. If it is found that they had ever offered more than this, we will annul this settlement. Set you back to face the trial. So it's not that it was a reopener clause saying, if it is found you offered more, it will be done. Secondly, these volumes and volumes and volumes which have piled up and occupied space in your lordship's registry. Nothing has been ever suggested that Carbide offered more in any negotiation or any discussion than what was ultimately accepted. So that issue of the 1989 order is over. Now, what is the case in the curative? And I was going to, perhaps out of over enthusiasm, interrupting twice, give figures. What I was trying to point out is it is not the case of the government in the curative that they have had to pay a lot more than what was received in the settlement. Why should the taxpayer be burdened? That is not the case of the government. The case of the government is for the hugely larger number of cases, the 520, 530,000 claims which have come, we have had to pay 1,548 crores. But then we still had 1,500 left in the kitty because of various reasons. So the court directed us to pay the balance back, also pro rata. So it's not the case that the government is out of pocket for anything. What then is the case? The case is, and that 600 crores figure is very important. We paid 1,500 crores, so around one. Forget the surplus which was given pro rata. We paid 1,500 odd crores. The settlement, what we wanted 500 million or 470 million, roughly the dollar was about 18, 19 that time. It's about 900 crores. So the 89 money we got is about 900 odd crores. We paid 1,500 crores. 725 crores with interest. We paid 900 crores. The 600 crores, therefore you add that on. That 600 crores what we have paid over the 89 figure, government should be asked to pay. And how? They are now saying, now take the today net present value of that 600 crores in 1989, taking into account various factors. And that becomes a few thousand crores. That is claim number one. So it is not one of that after paying all that, there is still 675 to pay. Let's be very clear on what this security is about. If your lordship sees 2 pages, this comes out very clearly. It will be. Because what your lordship will have to decide as a matter of law is, does this kind of a claim fit within your lordship's security jurisdiction? Page 329 of volume 2 of the curative petition sets out the figures. As the papers are being handed over, I just want to mention, I didn't want to bring it up earlier, but since petitioners 2 to 6 have claimed to be petitioners 2 to 6 and are argued, there has been an adjudication of whether UCC is liable or not liable. The American lawyers led all this evidence which they want to place before. The district court said, you have not established UCC's control over the Indian company. The Indian company was a listed company. It made departures from the technical designs given by UCC. It was not being run by UCC. What happened was an industrial accident in the operation, not in the design. Therefore, UCC is not liable. I'm not saying that's right or wrong. That's the finding of a court on adjudication. This was the concern of the government of India in the suit. Because then you would be left with UCIL, who had 100 crores, 200 crores worth of us. They carried it in appeal, and the appeal got dismissed. Now, this is where the only adjudication has taken place. But it's not relevant for us. But since these 2 people have come, they should have candidly told the court, well, we've tried holding UCC responsible, we failed, so we are back here. Please, Bharat, turn to page 329, P7. And since Bharat, it's only 5, the Lordship asked, what about the toxic waste? Since I know, Bharat, I'm appearing in the other case, my friend and I have been appearing in that other case. I tell your Lordship, Needy gave reports because 84, when the accident happened, the CBI came, they yellow taped the property and kicked out. I think in 89, the government of Madhya Pradesh cancelled the lease. 92, they cancelled the lease of UCR. They took a factual possession was always with the police or this. Then the legal possession also, they said, you're out, we are taking possession. Up to 1997. Now, what is toxic waste? Toxic waste is substandard pesticide. Well, today, nobody uses that kind of pesticide, but at that time, government of India wanted this pesticide to be used for our agricultural crops. Pesticide which was not strong enough was kept in pits for ultimate decay and destruction. Up to 1997, Neary says there is no contamination. First time Neary found contamination in the water was in 97 because nothing was done. This waste was lying on the ground. Now, what happens in these pits is not every few years you have to change their base, you have to change their lining, you have to do something. Nothing was. So the lining decayed. Because the lining decayed, leaching took place. Leaching took place 7-8 years down the road. The water contamination and other troubles started. So this is what has happened. And that the concerned people have filed petitions under the government. Justice Ravindran, his lordship then was sitting in the Madhya Pradesh High Court. He said, he told the government, and the government's defense there was, ask Union Carbide to pay, ask the Dow Chemical Corporation. Dow Chemical Corporation acquired Union Carbide in 2000. They had no connection in 1984, 2001. Ask them to pay. So they were getting bogged down on is Dow Chemical liable, are they not liable? Justice Ravindran said, you first get the place cleaned up. Then you worry about who's going to pay for it, because ultimately, if it is going to affect the health and lives of people in that area, you first get the junk cleaned. That's where things are. Matters still pending. So it is not that nothing. That's a matter which is pending in the High Court, and the High Court
That is receiving separate attention there.
Yes.
Just to add, my lords, there's an SLP from that High Court which is pending before this court.
Which is disposed now.
No, my application has not been disposed.
I see. SLP
There
and
are
government
two matters.
application is pending. Right.
My lords, I have the order here. In the research foundation matter, there were various IAs, etc.
I can't take anything from
If
her time because her time is over.
If the SLP,
It's here, my
no, if the SLP is over, the presumption is no application survives.
My lords,
I'll
there are
clarify, my lord. There were two matters. One was the research foundation dealing with hazardous waste. So in that, my lord, they also dealt with partially with the Bhopal case. They said it should be cleaned. So in that, there is application which has been filed, must be pending. That SLP has been disposed of, which my learned friend. So that application is happened.
Got it.
so my lords,
Anyway, Malak, let me come
request
back.
is pending here.
It is not before us.
Anyway, Malak,
My lords.
I have no time to take from them, so let me not waste time on this. Let me get on with what I have to show the court. May I start at 2 because I have to read some pages.
See, the whole case which is laid out is this: you pay the particular figure. Now, what accrues and increases on that figure cannot be taken into consideration while quantifying the amount, because that figure, if it was depreciation of rupee or interest,
Yes,
as it is done in so many cases in the
absolutely. My point is very simply this. If the rupee had climbed against the dollar, I should have asked for a refund.
that figure remains static. For you, that figure remains static.
That's the long and short of our case.
Lordship, my request, board of court number 7 can be discharged. Waiting for that.
Yes, it will be discharged.
But there are alternative boards.
Yeah.
In
The
fact, I was
alternative
also going
boards
to
are
request.
here also, but we are
But if I may say so in a lighter vein, if your lordship want me to finish quickly, then please don't take the alternative board. Otherwise, like Mr. Ramaswamy used to say, I will have to go on till 4 o'clock.
no alternative boards.
Lordship.
Your board. They have also board.
So no,
Our board is
no
of course
alternative board we are taking.
Lordship.